So now we'll discuss the very idea, that is burden of proof in negligence. The general is that the onus of proving negligence is on the plaintiff. He must not merely establish the facts of the defendant's and of his own damage, but must show that the one was the effect of the other. A relevant factor in this connection is whether there was any contract between the parties in a case where some seamen were injured in a tanker explosion and filed an action against the Coast Guard Authority for negligent inspection of the vessel. They produced neither evidence that they were aware of the inspection having taken place, nor evidence of that there were any alternative measures they could have taken. In cases, however, there is a contract or personal undertaking, the plaintiff must prove such contract or undertaking and injury to himself. The mere fact of an injury happening, if unexplained, is evidence of negligence. It is for the defendant to prove that he himself was exercising due care, and as it was laid down in the leading case, I.K.C. Kumanan versus Vallabhdas in 1969, that in a suit for damages for injuries caused by an accident, the initial burden of making out at least a prima facie case of negligence against the defendant lies heavily on the plaintiff. Once this onus is discharged, it will be for the defendant to prove that the incident was the result of inevitable accident or contributory negligence on the part of the plaintiff. Similarly, in Sitama versus Benedict D Suza in 1967, it was observed that in proceedings for compensation on ground of negligence of a motor driver, the burden establishing actionable negligence on the part of the driver who drove the motor vehicle is entirely upon the claimants. It is for the claimant to prove negligence. Again, under certain circumstances, the mere happening of an accident will afford prima facie evidence that it was the result of want of due care. So, this is regarding the very burden of proof of negligence. And as we have discussed, the leading case I.K.C. Kumanan versus Vallabhdas 1969 and Sitama versus Benedict D Suza of 1967. From these two above leading cases, one conclusion is derived, that is the very maxim of res ipsa locutor, and which exactly means the very thing speaks for itself, and that we will discuss in our next video.